are telling the court under oath, risking perjury and contempt, that this signature is Mr. Snoozouski's?
Yes.
Did you sign this document?
No, I did not.
Did you request Ms. Looker and/or Ms. Bulu to sign this document?
No.
Okay, the court received a letter on July 28th, 2025, in which it is purported to be an agreement between all parties in which Mr. Snoozouski will promise to drop the eviction and complete the dismissal of the eviction through the court, and they will no longer be responsible for all matters regarding the trailer and property at the location, and all legal matters in regards to materials, property, and financial debts, including the $5,350 for the judgment in that case, will be dismissed, and Amanda Looker and Jennifer Bulu will no longer be held responsible now or in the future, as long as they vacate the trailer and the property no later than April 18, 2025. And this written contract will become null and void, and the eviction and any legal matters regarding this case will stand as the judge ordered if they do not vacate. And then by signing this written agreement, both parties agree that this is a legal binding document, and it appears to be signed by Ms. Bulu, Ms. Looker, and then on page 3 of 3 by Mr. Snoozouski with the date of April 17, 2025. Ms. Looker and Ms. Bulu, is this the filing that I received?
Yes.
The father lays out his frustration, calmly but firmly explaining that he has had the children almost full-time for years while still paying child support. The judge listens closely, steering him away from emotion and toward facts. Right away, it's clear this case will hinge not on feelings, but on what has actually been happening versus what the order still says.
How did this document come to be?
I guess after court, when we had court, she stopped us out in the hall and asked us to write up something, and that he would come over and we would sign it. And so I was like, okay. And he's like, that he would squash everything if we just go. And so we're like, absolutely, let's do it. And so we filled it out and, brought it up, and then he came and signed it. And then all of a sudden we find out that he's saying that he didn't sign it.
All right, so you are telling the court under oath, risking perjury and contempt, that this signature is Mr. Snoozouski's?
Yes.
Who actually drafted the document?
I wrote it up per his request.
All right, Mr. Snoozouski, did you sign this document?
No, I did not.
Did you request Ms. Looker and/or Ms. Bulu to sign this document?
No.
Or to prepare this document?
No.
You then filed your own response.
Focus narrows to custody and overnights. Numbers matter here, and the father's estimate of only a handful of nights per year lands heavily in the room. The judge asks precise questions, clarifying ages, school status, and schedules. Every answer tightens the frame. This part shows how courts dissect daily life into measurable pieces, because custody isn't about intentions, it's about consistent, provable patterns.
That you state that you are stating that it is not your signature, that you did not agree to this, and that the signature is forged. And
Yes.
you've provided copies to the court with multiple copies of documents that have your signature on them. Is that correct?
Yes.
Are you asking the court to receive those as evidence here today?
Yes.
Did you bring additional copies?
Yes.
Okay, can you provide copies to Ms. Looker and Ms. Bulu? And then if you have an extra copy for the court, I just have what I go off of when I prepare for a case.
Okay, I don't have a copy for them.
But you have a copy for the court? I can receive it as if you're filing unless you have additional documents.
Yes,
Yeah, but
yes, I have a copy for them and for the courts.
Judge, do you want these marked as an exhibit?
The conversation shifts to legal versus physical custody, and confusion surfaces. The father admits he filed broadly out of uncertainty, not strategy. The judge explains the difference plainly, cutting through misunderstanding. This exchange is revealing because it shows how easily parents misinterpret legal terms and how those misunderstandings can snowball into years of financial and legal consequences.
Or do you just want them?
Are they the exact same as in this petition?
I can't say for sure.
We should just mark it as an exhibit.
Okay.
It looks the same as what he filed, but it is the same as that he filed, but we can still mark it as an exhibit.
Okay.
Okay, and so Mr. Snuzuski, you have documents here, not only in the letter that you filed, that has your signature, and then you have 1, 2, 3, 4 other documents that you have filed that shows your signature. Is that correct?
Yes.
Anything you wish to add or let the court know?
Yes, the first I saw of the letter was when I received a copy from the clerk of court by email.
Okay. Ms. Looker and Ms. Bulu?
Yes.
we have,
We have text message copies we got copies for him as well as for you guys, I guess, of our text messages to like having a conversation about this exact agreement and stuff. And I kept them, and then I got that letter, and I was like, oh, God. So we printed them for you guys to see them.
Now the mother responds, and the contrast is clear. She speaks about effort and circumstances, not schedules. The judge redirects her again and again to the core question. Do you agree with changing the order to reflect reality? Her hesitation speaks louder than her words. In this moment, the gap between emotional involvement and documented parenting time becomes impossible to ignore.
So that
that
way
he said,
that he knew about the letter and he came to the house and could I bring it up to you?
Yes, have it marked as an exhibit, and please
Okay.
give him his
Okay,
copy.
sounds good.
What would you like me to know about these?
That he.
Well, you have to direct me to what you want me to look at, because these are multiple pages and I don't have time to read it.
Okay, sorry. Let's see. For sure, I guess on page, I think it's the third page. It's got like where we screenshotted it because he wanted to see a picture of what we drafted up or whatever, and so we sent it to him. And that's basically the most important thing, is to say that he did have it. And we also got, in case he said that it wasn't his because it's under Joe Landlord, we have other copies that we got of like it being his number and not his name under there, because I didn't want him to take a chance of saying.
You should file that instead of the
Okay.
Joe Landlord.
Okay, I thought it was super genius when I did that.
on like the 5th page, ma'am, it says, looks fine, are you home?
And you have to identify who you are versus
Oh,
who
I'm
the
sorry,
other.
Jennifer Bulu.
You're Miss Bulu and you're Miss Looker. Okay. On the 5th page. what?
Yep, I think it's the 5th page. 1, 2. It's after the copy of the The photocopy of the contract. It says, looks fine, are you home? That's him. And then we said, okay, yeah, and he says he was coming over to sign it.
All right, Mr. Snezewski, what's your telephone number?
901.
It is the telephone number that is identifying on exhibit number 102. Is that correct?
The judge explores whether an agreement is even possible. Parenting time as agreed sounds flexible, but flexibility without structure often fuels conflict. The daughter's wishes are mentioned, adding weight to the next steps. This section highlights how courts balance a child's voice with legal standards, carefully preparing the ground for a more formal.
What page is that?
Page, well, any of the pages, the number that's on top of each of the text message chains.
I just see Joe landlord.
The
Second copy I gave.
other copy.
Oh. Yes.
So that is your telephone number?
Yes.
And this is a conversation that you had with either Ms. Looker or Ms. Bulu?
Yes,
And so you
but
did enter into an agreement with them?
not about the dropping the eviction or the judgment.
On page 4 and on page 5 are screenshots of the agreement. And it appears to be the exact same agreement that the court has in front of me.
Okay.
And it states what I recited on the record, even though I did not state it verbatim.
Said, I don't remember signing it. I don't remember seeing it.
But you're admitting that this is your text number?
Yes, it is my text.
And this is the conversation you had with Ms. Looker and Ms. Bulu.
Yes.
And so when it says on page 1, I'll sign a document if you can write it up. And then they respond, thank you. Then I don't know what YW means. That you responded. And then they responded, we will have something written up tomorrow if you want to stop over sometime and sign it.
Negotiations stall and the courtroom tone changes. When agreement fails, procedure takes over. A hearing date is set, and the requirement for the child to appear is explained. This is the turning point where the case leaves discussion mode and enters evidence mode. Once that happens, opinions matter less and preparation becomes everything.
Just let us know what time works best for you. You stated, I'm not going to sign anything until you're out completely. I do a walkthrough and I change the locks. I can be there Wednesday at 8:30 to noon if that works. And send me over what you have when you have something written up. And then it appears that we're missing some text messages because it goes, that wasn't the agreement we made in the courthouse. So it appears that we're missing some text messages.
Just the very end of
Yeah,
where it says, please call me. I don't know what I'm going back on.
No, where we're looking at page 2, and then we're looking at his response and send me over. Well, oh, I guess maybe you're saying that
Oops.
when he said he's not going to sign until you completely move out. Is
Yeah.
that what you were talking about?
Yeah.
Mm-hmm. And then he said, send me over.
And then please call me. I don't. So, no, I'm going back on what we talked about is what he responded. You responded, I am so sorry I didn't get your message until just now. You should just have come to the door. We should have the paperwork ready to go to meet you somewhere to sign it. Also, did you figure anything out about the water? Mr. Snezewski, you said you'll be there around 2. And then a little later on that page is the first part of the screenshot of the document. On page 4 is the, where you respond, on my way, be there in 15. And they say, I'll send you a photo of it so you can read it. And then there's the first page screenshotted of the exact document the court has. Page 5 is the second page of the screenshotted document. Page 6 has the third page of the document where it's just Mr. Snuszewski's place for a signature. You respond, looks fine, are you home? They respond, oh, okay, yes, we are home. We will watch for you, or for ya, but you mean for ya. And you said, I'm here. They said, be right there. You respond, text me when you get out. They respond, I will for sure. You respond, TY for thank you. And then nothing. It goes to 2 hours later at 9:32 p.m. They send a text to you. So I couldn't find anyone that would make a copy of our agreement any place today, but I can email you your copy if you'd like. Then they responded again 2 hours later at 11:37 to you. Sorry, I forgot to message you. We left the house at about 10 p.m. I don't know if there's anything missing in between there or if there's a conversation. And then you respond at 7:05 a.m. the next day on April 19th. That would be fine to email me a copy. And I'm missing one because then it goes, Amanda is not here for a few days and she forgot her cell phone. I don't know what all that one says.
That was from her mom to him about a dog kennel
Oh,
that we had
Yeah,
left at the property.
and then they send a text to you. I have printed physical copy of the court order saying we can be there till the 30th. And since you haven't dropped the eviction yet, a week later means we absolutely are allowed to go back to the trailer till 11:59 p.m. on April 30th, 2025. And there isn't a thing the cops can do about it either. I am not trying to be rude, by no means at all, I promise. You respond, call the cops. And then a little further down, and then you say, I knew you were going to pull something like this. That's why I was going to wait until the 30th. And then they say, unless you follow through with your end, our agreement prior to 4 p.m. I don't know what that means. So, Mr. Snuszewski, I'm going to tell you, it looks to me like you signed it.
I don't remember signing it.
I'm going to say this doesn't look like your signature. I can tell you that. It doesn't look like his signature at all. But I'm going to tell you that if they didn't have these text messages,
Yeah.
I would have said it wasn't your signature and you didn't sign it. But this is exactly very clear, message by message by message, with the exact document, with what I read on the record, again, not verbatim. And in the text messages, it indicates you signed it. Did you sign it?
I don't remember signing it.
You could have signed it.
The issue of child support takes center stage. The father presses the financial strain, but the judge draws a firm legal boundary. Support can only be modified back to the filing date, not years into the past. It's a hard rule and an expensive lesson about waiting too long. The path forward is clear, even if it's not painless. Like the video, subscribe to the channel, and we'll see you in the next video.